Let's get specific about what should actually concern authors and thought leaders right now, because it isn't an AI might read my book. If you're building a business around your expertise and your book as a core part of that strategy, the real risks have been sitting quietly in the background for years. AI hasn't created them, it's just made them impossible to ignore. In this video, the third in my AI and author rights series, we're going to look at the potential risks hidden inside your author contract and what's actually worth your attention. Risk number one is signing away rights that you don't fully understand. This has been the single biggest risk to authors for decades, long before generative AI existed. Broad, perpetual, all rights contracts, work for hire clauses, vague language around future technologies and formats not yet invented. These things have been quietly sitting in publishing contracts for decades. Now, here's why this matters so much in practice. A work for hire clause typically means that regardless of who physically wrote the content, the commissioning party is treated as a legal author and owns the copyright outright. If you've ever worked with a ghostwriter, co-author, agency, or publisher under this kind of arrangement, the rights to that content may never have belonged to you in the first place, even if your name is on the cover. Similarly, perpetual, worldwide, all-format licensing language, common in traditional publishing contracts, often grants the publisher rights that extend far beyond the printed book into audio, translation, serialization, anthology rights, and yes, increasingly, AI training and licensing rights. Now, these clauses were frequently signed without much scrutiny because in practice, they rarely seemed to matter. Nobody was fighting over audiobook rights to a 10-year-old business book. But AI has changed that calculus because suddenly there's a commercial use case, training data, licensing to AI companies, AI generative derivative content for rights that previously just sat dormant. AI has simply made the consequences of those clauses more visible and more immediate. If a contract that you signed years ago includes a clause covering any future technology not yet invented, that clause may now apply to AI training and licensing in ways that you never anticipated when you signed it. And the only way to know for certain is to actually read it, ideally with somebody who knows what to look for. Risk number two is platform dependency. If your authority, your audience, and your distribution all live inside somebody else's ecosystem, for example, a publisher's catalog, a single platform's algorithm, or a third party's term of service, you don't actually control the asset that you've built. You're renting your own visibility, and the terms of that rental can change at any time, often in ways that you only discover after the fact. This risk takes a few different forms. There's the publisher form, which includes things like your book's availability, pricing, metadata, and promotional placement are largely controlled by your publisher or your distributor. And if that relationship changes or the platform's policies shift, your book's visibility can change overnight with no action on your part. There's also the platform form, i.e., if the bulk of your audience finds you through a single channel, whether it's a particular social platform, particular marketplace, particular newsletter host, and that platform changes its algorithm, its terms of service, or its policies around third-party content and AI, your reach can shift dramatically through no fault of your own. And there's a newer form that's specifically relevant to AI, and that's the platform's terms of service increasingly including clauses about how content posted on them can be used for AI training by either the platform itself or by partners it licenses data to. If your articles, excerpts, full chapters have been published on third-party platforms over the years, it's worth understanding what those platforms' current terms say about AI use, because those terms can be updated retroactively and may apply to content that you posted long before AI was ever part of the conversation. The common thread across all of these is the same. The less of your distribution that you control directly, the more your visibility and your IP is subject to decisions made by someone else for reasons that you may have nothing to do with you. So let's look at a specific case study, the Anthropic settlement. Now, you've likely seen headlines about Anthropic. They're the AI company behind Claude, reaching a proposed $1.5 billion settlement, pending final court approval at the time of this recording, with authors over how some of its AI training data was sourced. It's worth understanding what actually happened here in a bit of detail, because it's a near perfect illustration of the risks that I've just mentioned. And because the headline figure tends to obscure the most useful part of this story. The case centered on a class action brought by authors who alleged that millions of books had been used to train AI models without permission. The court's findings, when they came, drew a clear and important distinction between two very different things. First, training an AI model on books that were legally acquired, i.e. purchased, licensed, or otherwise obtained through proper channels, was found to be transformative and protected. The court treated this as a legitimate use and not the issue at the heart of the case. Second, and separately, a large portion of the training data in question had not been legally acquired at all. It had been downloaded from shadow library sites, places like Library Genesis, which had been hosting pirated copies of books for years, long before any AI company came looking. This was the part of the case that resulted in the settlement. Now, this distinction matters enormously. It means the legal exposure wasn't really about AI training on books as a concept. It was about sourcing training data from a piracy ecosystem that already existed, was already operating at scale, and had already been quietly distributing authors' work without consent for years. In other words, those books were already stolen. The privacy infrastructure existed well before generative AI was a mainstream concern. What AI training did was pull from that existing pool of pirated content at scale, and in doing so made a problem that had been quietly tolerated by the industry for years suddenly impossible to ignore. And in this case, suddenly very expensive for the company involved. Here's the pattern worth sitting with. The arrival of publicly accessible AI did not create a copyright crisis. It accelerated and amplified one that already existed, exposing how much unauthorized copying, licensed and unprotected IP had been sitting in plain sight for years, simply because no one had the tools or incentive to act on it at scale. Shadow libraries containing millions of pirated books have been operating for years before any AI company built the large language models. Authors' work had been circulating without consent, without payment, and without any practical means of enforcement, because individually pursuing each instance of piracy was never realistic. What changed wasn't the existence of the piracy. It was what AI training gave the piracy a new, highly visible, commercially significant downstream use. Suddenly, there was a deep-pocketed defendant, a clear commercial benefit being derived from the stolen content, and a legal mechanism, a class action, capable of aggregating hundreds of thousands of individual claims into something courts could actually act on. Now, for authors and IP owners, the lesson isn't be afraid of AI. The lesson is the gaps in how your work is protected, licensed, and tracked were always there. AI just made them matter faster, and in this case, made them matter in a way that resulted in real compensation for affected authors. Now, that's not a reason to relax. It's a reason to get ahead of the next version of this story, rather than finding out after the fact that your work was part of it. So where does this leave you? Neither of these risks, unclear contracts or platform dependency, is new, and neither is unique to AI. What has changed is the spotlight. The question now is whether you know what's actually in your contracts, and whether you control the platforms that your authority depends on. Now, this isn't about panicking about AI. It's about positioning. The authors who come out ahead of this won't be the ones who shouted about AI the loudest. They'll be the ones who understood early on exactly what they owned and exactly what that ownership was worth. Next week is our final installment in the AI and author rights series, and I'll be talking about how to look at the AI versus authors argument in a completely different way. So be sure to like and subscribe to the channel so you don't miss out on this all-important final installment. But until then, happy publishing.